Judgment in the appeal, BPE Solicitors and another, and Hughes-Holland.
Lord Sumption will explain the decision of the court.
This appeal raises one of the classic problems of the modern law of damages. Mr. Little is a builder and developer. In 2007, he had a project to develop as an office building a disused heating tower on Kemble Airfield in Gloucestershire on a site owned by one of his companies. He estimated the cost of development at £200,000. He borrowed £200,000 from a friend, Mr Gabriel, who is the effective claimant in this action. At the time of the loan, there was a misunderstanding between them about the use that would be made of the loan money. Mr Gabriel assumed that it would be used to fund the development costs. But Mr Little had other ideas. He proposed to use it to pay off an existing debt owed by one of his companies that had nothing to do with the airfield project. It is far from clear how, in those circumstances, Mr Little proposed to fund the development, since he appears to have had no other source of free funds. No doubt he hoped, like Mr Micawber, that something would turn up. For present purposes, what matters is that Mr Gabriel would never have agreed to lend the money if he had known what Mr Little intended to do with it. Unfortunately, Mr Gabriel's mistaken understanding about Mr Little's intentions was accidentally confirmed by his own solicitor, Mr Robert Spencer of BPE Solicitors in Cheltenham. Although Mr Spencer was acting for Mr Gabriel, he actually received his instructions about the transaction from Mr Little. Mr Little told him hardly anything about the development project. He simply told him to draw up a facility letter recording the terms of the loan and a charge over the property. Mr Spencer used a template for the facility letter which recorded that the loan money would be spent on the development, and this clause found its way into the document as signed. Mr Gabriel saw the clause and was reassured. He signed the loan agreement and advanced the money. The project was a financial disaster, and he lost almost all his loan. Now here comes the problem. Mr Gabriel says that he's entitled to recover the whole amount of his loan as damages, because he would never have made the loan if the solicitor's draft facility letter had not negligently misled him about the use to be made of the money. It is true that the facility letter did contain an incorrect statement that the money would be spent on the development. But the reason why the project was a disaster was not that Mr Little actually spent it on other things. The reason was that the whole project never did stack up financially. Even if the £200,000 had been spent on the development, as Mr Gabriel had led to expect, it would still have been a disaster because Mr Little had greatly underestimated the development costs. Mr Spencer was not responsible for that. Therefore, said the solicitors, he shouldn't be liable for damages at all. The judge held that Mr Gabriel was entitled to the whole loss. The Court of Appeal held that he was entitled to nothing. The Supreme Court unanimously holds, in agreement with the Court of Appeal, that he was entitled to nothing. In order to recover damages, it is not enough to show that but for the defendant's breach of duty, the claimant would not have entered into the transaction and would thus have avoided the loss. There must be a sufficient relationship between the loss suffered and the particular respect in which the defendant broke his duty. In some cases, a professional advisor undertakes to advise on just one aspect of a proposed deal, leaving the assessment of all the other aspects and a decision whether to proceed on the whole of the material available to his client. In these cases, the advisor does not assume a legal responsibility for the decision to proceed. He only assumes a legal responsibility for the advice that he gave on the limited aspect that he was actually concerned with. Most cases involving valuers or solicitors belong in this category of case. In other cases, the professional advisor undertakes to advise on the whole range of factors that may be relevant to the decision whether to proceed with a transaction. In those cases, if the advisor is negligent, he will be liable for all the foreseeable consequences of the transaction turning out badly. An investment advisor advising on a proposed stock purchase might well fall into this kind of category of case. Mr Spencer clearly fell into the first category. His only responsibility in relation to the proposed loan transaction was to take reasonable care to get the documents right. He negligently got them wrong, but he had no responsibility for the financial viability of the transaction, and it was because it was financially unviable that Mr Gabriel lost his money. Mr Spencer's employer cannot be liable for a loss that Mr Gabriel would have suffered, even if the whole of his loan had been applied to the development in the way that he had been led to expect. The Court of Appeal was therefore right to dismiss his claim for damages.